And I move the motion in my name and that of my Labour and Sinn Féin colleagues, item 74. And I move it in the shadow of yet another tragic death. Can I suggest, Ceann Comhairle, that I'm sharing my time with Deputy Liz McManus and Deputy Cuivon Quaylon, if that's agreeable, 15 minutes, 5 and 20. As I say, I move this important motion tonight in the shadow of yet another tragic death, this time by murder of a child in the care of the HSE. We don't know the full story of the life and the death of Daniel McAnespie. What we do know is disquieting and a real cause of concern. So as we have done already today, and collectively will do it tonight, send our condolences, heartfelt and real, to Daniel's family, we must resolve to do more. It was in February 2007, more than 3 years ago, that the then government presented the 28th Amendment of the Constitution Bill to this House. After many, many years of debate and consideration, there was 3 odd years ago a consensus that we needed to change the Constitution to give greater rights to children. Children's rights organisations, some of whom are represented in this House tonight, have long argued for this change. But the vulnerability of children, their lack of unique constitutional presence in the Constitution, and the consequences of this situation has become now a matter of real and urgent concern. Going back to the conclusions of the Kilkenny incest case of 1993, and I remember it well, Deputy Shatter will remember it, when we set up a committee of investigation and asked then Senior Counsel Catherine McGuinness, now Mrs Justice Catherine McGuinness, to head that investigation. Among her important recommendations, and that of her group, was, and I quote, that a specific and overt declaration of the rights of born children should be included in the Constitution. Since 1993, a number of other reports, a number of other court cases involving individual children and their families have continued to raise the question of the apparent conflict between the best interests of children and the rights and duties of married parents. In too many cases, professionals or courts involved in decision-making relating to children make decisions on the basis of our current constitutional balance and failed to act in the interests of the child. And children have met with harm, sometimes unimaginable harm, because of this approach. This House has debated many of these reports, many of these cases, over the past 15 years. In 2007, it was decided that we needed to act to bring about real and substantial change. And the government, as I say, published a constitutional amendment bill. The 2007 bill, which proposed the insertion of a new Article 42A into the Constitution, was referred to an all-party committee for detailed consideration. That committee met weekly and examined in very minute detail, as the Minister of State here present will remember and recall, examined the law relating to children. In September 2008, the committee presented its first interim report. This report dealt with a proposal to give legal authority for the collection and limited exchange of information concerning the risk of the endangerment, sexual exploitation or sexual abuse of children. It was our unanimous view that the gathering and limited exchange of so-called soft information could be achieved by legislation without the need for constitutional change. Since this was a prime recommendation in the Ferns inquiry report and featured in other horrific cases, such as the Soame murder case, where Holly Wells and Jessica Chapman were murdered by local school caretaker Ian Huntley. The committee believed that urgent legislation was required, and we made that recommendation, as I say, in September of 2008. Unfortunately, a year and 8 months later, we still await the publication of this important bill. The committee then set to work on the difficult and complicated proposal to give legal authority to create offences of absolute or strict liability in respect of sexual offences against or in connection with children. That work and a very detailed report, the second interim report of the committee, was presented to Dáil Éireann in May of last year, May 2009. The majority of the committee recommended the creation of offences by legislative means. We again await the response of government to this very detailed report. Here too, urgently required and needed legislation that people will recall mobilised thousands of people to gather outside this House has been long promised and yet not delivered. The third and final phase of the committee's detailed work dealt with the remaining issue of required constitutional change. Specifically, the issues of children's rights, children's rights, the best interest of the child, the power of the state to intervene in the family, and the issue of adoption. Again, an extraordinary amount of work, research, hearing of evidence, and consideration of detailed submissions informed the debate that shaped the ultimate recommendations of the committee. It was our shared view from an early stage that the published 2007 bill did not go far enough to achieve the aim of enhancing children's rights. And from an early stage of our deliberations, all members of the committee from all shades of opinion and all parties grappled to see if we could shape a wording that we could agree upon and that would really be an advance in children's rights, a groundbreaking advance. I believe it to be a remarkable achievement to have produced in February of this year, some 3 months ago, an all-party agreed set of proposals, including an agreed set of words. Quite frankly, many times during the committee deliberations, I didn't believe we would reach that momentous moment. But we did reach it. This report followed what was probably the most comprehensive examination of the truly complex issues involved in trying to enshrine and enhance the protection of the rights of children. I pay tribute, as I did on its publication, to all members of the committee who worked under the able chairmanship of Deputy Mary O'Rourke. In a non-partisan way, the committee worked to address these complicated and delicate issues involved. The final report enjoyed the support of all members representing all political parties elected to this Oireachtas. We have benefited from the participation directly on the committee of the government through the Minister for Justice Dermot Ahern and the Minister for Children Barry Andrews. For that reason, one could hope and expect a speedy response to the committee's groundbreaking proposals. Clearly, we are all agreed that few issues better demand our attention and our action. And unlike most committee work, there was nothing new presented to government 3 months ago. They'd been fully engaged with the arguments, the genesis, and the conclusions. And the parties that constitute the government signed up to those proposals. And this motion tonight, sponsored by the Labour Party and Sinn Féin deputies, seeks to now move this process along because it urgently needs to be moved along. We have waited long enough for this change. Dáil Éireann must again unite on this issue and remain united, endorse the draft wording for constitutional change recommended unanimously by the committee, and announce our determination to bring this proposal to the people this year. It is said by some that government will not agree to a referendum this year for fear of having to hold the by-elections that are due. That simply cannot be tolerated as an excuse for inaction on this issue. The welfare of children and the failure of state and church and society to give them adequate protection has convulsed this House and the nation. Our words of determination to do better, which followed every report and every debate in this House, to act decisively in the interest of children, will ring hollow indeed if we long finger this much needed and urgently required change. This proposal will require detailed explanation and debate and engagement with the people of Ireland. That will require time. The sooner we complete the legislative phase of the Constitutional Amendment Bill, the sooner we can start the process of real engagement and dialogue with the electorate whom we must persuade to pass it. There have been, and we've heard them, a few voices of concern. Any change gives rise to proper questioning. We need to know now the government's intention so that those fears are not fanned by the vacuum of inaction. In short, we need to start a detailed process of communication with the electorate. So what is recommended in the words proposed? We recommend a new Article 42 to be entitled Children. This new article sets out the recognition of equality between all children. No more married children, or the children of married parents and the children of unmarried parents being unequal before the law. The recognition of children's natural and imprescriptible rights vested in themselves. The right to have their welfare regarded as either a primary or a paramount consideration. The right to protection and to care. The right of the child's voice to be heard. It acknowledges parents as the primary and natural carers, educators and protectors of the welfare of their children, and guarantees to respect those rights and responsibilities. It would allow the state where parents fail in the responsibility to either supply or supplement the place of the parents by proportionate means. It would provide for adoption of children where the best interests of the child so require, and it reenacts the existing provisions dealing with the rights of parents to provide for the education of their children. These and the other recommendations listed out in the 117 pages of the report can make a real difference, an historic difference, but only if they're acted upon. Too many sad, depressing, horrific reports on the abuse of children have come before this House. Just as we united in expressions of outrage when we read of the abuse of children, let us now unite in our determination to, in a concrete fashion, make things better. The committee did not divide on party political lines. Let us not divide now. The proof of our sincerity on these issues... The proof of our sincerity on these issues will be provided in our deeds and not in our words. I must say, I am profoundly disappointed to read the amendment proposed by the government, because I believe in the goodwill and in the determination of the current Minister for Children to bring about real change. But he must be supported by this House, and he must demand the action of the Cabinet. Pass this motion tomorrow evening. Let us show a common determination to act on this issue for the common good of all our people, particularly the children of this country.